Complex Conversations. In this podcast, we hope to make complex living simple by explaining the law related to sectional title schemes, homeowners associations, and other community schemes in South Africa. I'm Jennifer Paddock, a dual qualified lawyer and director here at Paddock's, a specialist community schemes law and training firm. In this episode, I'm going to be discussing pets in sectional title schemes. We'll be covering what the law says about keeping pets. Is a body corporate entitled to adopt a no-pet rule, banning pets entirely? Is a body corporate entitled to allow some pets, for example, cats, but not others, such as dogs? What about emotional support animals and therapy pets? And finally, what can a body corporate do if it wants an owner or occupier to remove a pet from a scheme? So let's start with what the law says about keeping pets in sectional title schemes. Prescribed Conduct Rule 1, contained in Annexure 2 to the Sectional Title Schemes Management Act, deals with the keeping of animals, reptiles, and birds. It reads as follows. 1.1. The owner or occupier of a section must not, without the trustee's written consent, which must not be unreasonably withheld, keep an animal, reptile, or bird in a section or on the common property. 1.2. An owner or occupier suffering from a disability and who reasonably requires a guide, hearing, or assistance dog must be considered to have the trustee's consent to keep that animal in a section and to accompany it on the common property. 1.3. The trustees may provide for any reasonable condition in regard to the keeping of an animal, reptile, or bird in a section or on the common property. And 1.4. The trustees may withdraw any consent if the owner or occupier of a section breaches any condition imposed in terms of Subrule 3. Okay, so what does this rule actually mean? It means that apart from disabled persons, any owner or occupier must not keep an animal, reptile, or bird in a section or on the common property unless they first obtain the written consent of the trustees, and the trustees must not unreasonably withhold that permission. The trustees must give reasonable consideration to any request for permission to keep a pet, and this means that they should discuss and consider the issue at a meeting. The minutes of that meeting should disclose their decision and set out their reasons for approving or refusing the permission, and it must also set out the full text of any conditions imposed. The trustees must give any permission to an owner or occupier in writing, and the document should also set out the conditions imposed, and it must be signed by 2 trustees. The question of the reasonableness of the actions of the trustees in withholding permission and in the setting of conditions if they do give approval will turn on the nature of the animal, reptile, or bird concerned and the type of scheme. In dealing with any application for permission to keep a pet, the trustees should take into account the likelihood of the animal causing a nuisance to other occupiers and whether there are already other similar pets in the scheme. When granting approval to an owner or occupant of a section to keep an animal, reptile, or bird, the trustees may impose reasonable conditions, for example, that the animal must be on lead at all times while on the common property, and that the owner or occupier must clean up after the animal. If an imposed condition is breached, the trustees may, after ensuring that they are aware of all the relevant issues and having given the owner or occupier a reasonable opportunity to put forward their case, withdraw their approval. So if the trustees do withdraw their approval, they need to ensure that due process has been followed prior to that withdrawal, which means giving the person concerned an opportunity to be heard. It also means that the owner or occupier of a section who is suffering from a disability and who reasonably requires a guide, hearing, or assistance dog is considered to have the trustee's consent to keep that animal in a section and to accompany it on the common property. So this is an automatic granting of consent that Prescribed Conduct Rule 1.2 gives to persons who are disabled who reasonably require a guide, hearing, or assistance dog. So let's move on to the controversial subject of whether a body corporate is entitled to prohibit pets. Can they impose a no pet rule, a complete ban on pets in the sectional title scheme? So the Community Schemes Ombuds Service issued a circular on the amendment of rules in terms of the Sectional Title Schemes Management Act, and this was circular number 1 of 2021. And in the circular, it states that, and I quote, a scheme may prohibit pets entirely. However, that prohibition would not apply to a member or occupant that can show that he or she needs medical assistance and guide dog animal. Such animals are automatically permitted. Where the scheme introduces a no animal rule, where previously they permitted pets, they must take into account pre-existing pets. An owner that had a pet prior to the coming into effect of the rules must be permitted to retain that pet, but may be prohibited from replacing that pet if it dies, the so-called grandfather clause. Okay, so CSOS advises in the circular that a rule creating a blanket ban on pets is permissible, obviously excluding guide dogs or disability animals, which are automatically permitted, provided that a grandfathering provision is included in the rule, which allows existing pets to remain, but not to be replaced on their death. However, Professor Cornie van der Merwe, arguably South Africa's leading academic on sectional title law, disagrees with this. In an article entitled, "Is a Scheme Rule Prohibiting the Keeping of Animals in a Sectional Title Scheme Invalid? Lessons from the Landmark Decision of the New South Wales Court of Appeal," he writes, and I quote, "A rule containing a blanket prohibition on the keeping of animals is unreasonable and therefore invalid because it, A, does not provide a mechanism for the body corporate to consider the individual circumstances of each owner or animal. B, it unreasonably and unnecessarily precludes the exercise of the ownership rights and of use and enjoyment in accordance with contemporary standards, which include the entitlement to keep a pet. And C, it does not permit a balanced consideration of the multiple sides to the issue, but operates only in the interest of sectional owners who oppose pet ownership." In light of Professor Cornie van der Merwe's opinion, a body corporate may adopt a no-pet rule, which includes a grandfathering provision, obviously if supported by special resolution and approved by the CSOS, which it is likely that CSOS will approve such a rule given the circular. But the rule would be open to challenge by any owner who believes that they are prejudiced by the rule. And due to Professor Cornie van der Merwe's opinion that such rules are invalid, there is at least a reasonable chance that such a challenge would be successful. So I always advise bodies corporate to be very, very careful in considering whether to adopt a no-pet rule. I always advise it's better to leave the prescribed conduct rule in place and to consider each individual pet application on its own merits, given the particular circumstances of the scheme. Okay, so the third issue, is a body corporate entitled to allow some pets, for example, cats, but not others, such as dogs? So Section 10.3 of the Sectional Title Schemes Management Act requires that management and conduct rules must be reasonable and apply equally to all owners of units. Section 10.5b of the STSM Act provides that the Chief Ombudsman must examine any proposed amendment to a scheme's conduct rules and must not approve it for filing unless he is satisfied that such amendment is reasonable and appropriate for the scheme. So the requirement for reasonableness for rules means that in the circumstances of the particular scheme, a rule must be necessary, it must not be excessively wide in its scope, it must be based on good reasons, that is, it must be sensible in the circumstances and operate so as to promote the best interests of the sectional community. For example, in preserving the quality of life in the scheme or the value of the units as investments. The requirement that a rule must apply equally to all owners of units means that it must be of general application. So if a rule does discriminate, for example, allowing owners to keep cats but not dogs, such discrimination must serve a legitimate body corporate purpose and not be unfair or arbitrary. An example of discrimination that may be considered fair is if a scheme has sections with different facilities, such as ground floor sections with enclosed exclusive use garden areas, where none of the sections above have private gardens. In this case, it may be fair to treat the owners and occupiers of ground floor sections differently, for example, allowing them to have pets, while not allowing the owners and occupiers without gardens to have pets. Now, whether or not a body corporate rule allowing owners and occupiers to keep some pets, for example, cats, but not others such as dogs, would be enforceable, boils down to whether in the particular circumstances of the scheme and its community, such a rule is considered reasonable and whether the discrimination is considered fair, rational, and as serving a legitimate body corporate purpose. Now, there's conflicting case law on this issue. In the CSOS case of Isaac Daniel van Niekerk versus Island Gardens Body Corporate, adjudicator K. Mabaso considered an application in terms of Section 39(3)(c) of the CSOS Act for an order declaring a sectional title scheme rule prohibiting cats but allowing dogs unconstitutional. The adjudicator found in favor of the applicant, ruling that the cat ban was unreasonable in contravention of Section 10(c) of the STSM Act, and therefore the rule was set aside. On the other hand, in Abram versus Mount Edgecombe Country Club Estate Management Association 2, the circumstances of the scheme in question, which were that it was located in a nature reserve property estate specializing in the protection of bird life, was found to reasonably require a ban on the keeping of cats, and the decision that cats should be banned was considered reasonable. So the circumstances of the particular scheme will ultimately determine whether a rule allowing some pets but not others is likely to be considered reasonable or unreasonable for the purposes of Section 10.3 of the STSM Act and appropriate for the scheme in terms of Section 10.5b of the STSM Act. However, the default position, according to the leading case on the keeping of animals in sectional title schemes, Body Corporate of Laguna Ridge versus Dorse, is that when it comes to pet applications, the trustees must exercise their discretion in granting or refusing permission by considering the merits of each particular case. So as I said, my advice is always that rather than adopting either a no pet rule or a pet rule that allows some pets but not others, is that the trustees should ensure that each pet application, regardless of the type of pet, is genuinely and thoroughly considered on its particular merits and the actual circumstances of the scheme before deciding whether to grant or refuse permission. What about emotional support animals or therapy pets? So this has become quite a popular thing in recent years, especially for psychologists will prescribe a therapy pet or emotional support animal for people, for example, with depression, anxiety, post-traumatic stress disorder, etc. Prescribed Conduct Rule 1.2 states that an owner or occupier suffering from a disability who reasonably requires a guide, hearing, or assistance dog must be considered to have the trustee's consent to keep that animal in a section and to accompany it on common property. This rule aims to accommodate the needs of individuals with disabilities who rely on these specially trained animals for support and assistance in their daily lives. Therapy pets and emotional support animals are not specifically mentioned in Prescribed Conduct Rule 1.2, and they serve a different purpose to guide, hearing, and assistance dogs. These animals provide emotional support to comfort individuals with mental health challenges such as depression, anxiety, post-traumatic stress disorder. Unlike guide, hearing, and assistance dogs, therapy pets and emotional support animals do not necessarily undergo specialized training to perform specific tasks related to a person's disability. Therapy pets and emotional support animals are not currently regulated in South African law. However, it is generally accepted that for an animal to be considered a therapy pet or emotional support animal, it must be prescribed by a licensed mental health professional to a person with a mental health disability. So does Prescribed Conduct Rule 1.2 include therapy pets and emotional support animals, giving a person with a mental health disability an automatic right to keep that pet in their section and to accompany it on the common property? So Prescribed Conduct Rule 1.2's reference to an owner or occupier suffering from a disability could potentially be interpreted to include individuals with mental health disabilities who benefit from the presence of a therapy pet or emotional support animal. However, this interpretation is not without its challenges, as the rule specifically refers to guide, hearing, or assistance dogs, which are distinct from therapy pets and emotional support animals in terms of their training and functions. The reference to a guide, hearing, or assistance dog clearly limits the type of animal contemplated in 1.2 to dogs only, and further, only to dogs who have undergone specialized training to support disabled persons. As such, I would argue that the wording of Prescribed Conduct Rule 1.2 is not wide enough to include an untrained dog and is certainly not wide enough to include an untrained animal that is not a dog, like a cat. So how should the trustees handle applications for therapy pets and emotional support animals? Because just because I've argued that Prescribed Conduct Rule 1.2 does not automatically provide for consent for therapy pets and emotional support animals, this does not mean that these applications should be automatically refused. So in a scheme where they have the prescribed conduct rules, the trustees have discretion in approving or denying application for pets. And Prescribed Conduct Rule 1.1 states that an owner or occupier must obtain the trustee's written consent before keeping a pet in their section or on the common property. In cases where an owner or occupier provides supporting documentation from a licensed mental health professional recommending that they would benefit from the keeping of a therapy pet or emotional support animal, the trustees should consider the request carefully. While Prescribed Conduct Rule 1.2 does not explicitly cover these types of animals, it could be argued that they serve as assistance animals for individuals with mental health disabilities. And as such, the trustees should evaluate each case individually, taking into account the specific needs of the owner or occupier concerned, the type of animal, and the potential impact this animal may have on the community. They should also consider any reasonable conditions that may be imposed on the keeping of the animal to mitigate any potential nuisance that it may cause. It is crucial for the trustees to approach the issue of therapy pets and emotional support animals with sensitivity and understanding. Lastly, what can the trustees do if they want an owner or occupier to remove an animal from the scheme? So if an approved pet is causing a nuisance and the pet owner is not adequately addressing the issue, the body corporate can make application to the CSOS for an order under Section 39(2)(b) of the CSOS Act, which allows an adjudicator, if satisfied that an animal kept in a private area or on the common property is causing a nuisance or a hazard or is unduly interfering with someone else's peaceful use and enjoyment of his or her private area or common property, to make an order requiring the owner or occupier in charge of the animal to take specified action to remedy the nuisance, hazard, or interference, or to remove the animal. So The trustees are not able to remove the pet themselves. That would be something called spoliation, which is unlawful dispossession. They must go through the proper legal channels of applying to CSOS under 39(2)(b). Okay, if a pet is being kept without permission in contravention of the scheme's rules, the body corporate can make application to CSOS for an order under section 39(2)(c), which allows an adjudicator to make an order declaring that an animal is being kept in a community scheme contrary to the scheme governance documentation and requiring the owner or occupier in charge of the animal to remove it. If the application is successful and the respondent fails to comply with the CSOS order, the applicant can have the CSOS order made an order of court and submitted to the sheriff of the court for further execution. I hope that's been helpful, and I will see you next week for episode 4.